Last week, a Massachusetts jury convicted a California man of a sexual assault that happened in 1996. Now, for those of you familiar with the statute of limitations, it expired before prosecutors identified the man. So how did this all happen? WGBH's Adam Riley explains.
On October 19, 1996, a Boston woman let Derek Scott into her Brighton apartment in this building. He said he was selling magazines, but when Scott's sexual advances were rebuffed, he put his arms around the victim's neck, led her into her roommate's bedroom, and forcibly raped her. The victim reported the assault immediately and was treated at Beth Israel, where a rape kit was created. Now fast forward nearly 15 years to the fall of 2011. Authorities still didn't have a perpetrator, and the statute of limitations was about to expire. So a Suffolk County grand jury indicted John Doe, an unknown man whose DNA profile matched physical evidence taken from that rape kit. That kept the cold case alive. And then 2 years after that, authorities got a break. John Doe's DNA was matched with Scott's, who had a DNA sample taken after an arrest in California for drunk driving. He was tried in Massachusetts and convicted. The woman assaulted by Scott hailed the outcome in her victim impact statement, saying, "Now, after almost 20 years of reliving those horrendous events over and over and over, I can look at myself as a survivor rather than a victim." Still, John Doe DNA indictments do have their critics. Before the SJC upheld the practice in a separate case, opponents argued that it stacks the deck against defendants, writing, "Memories fade, witnesses die, and evidence deteriorates. The unfairness to a defendant in very old, stale cases is huge." But so far, no one is calling Derek Scott's conviction a betrayal of justice. Adam Riley, WGBH News.
Nor will I. Joining me now for more on this case, Baby Doe and more, is the Suffolk County DA, Dan Conley. Mr. DA, it's good to see you.
Great to be here, Jim.
Can we stay on this just for, there's no question justice was done. It's a terrific outcome, but you know better than anybody, statutes of limitation have a purpose. And following up on what Adam said a minute ago, DNA lasts indefinitely. Exculpatory evidence, memories fade, doesn't last forever. Isn't it possible you'll subvert justice as often as you obtain it?
Not in these cases, I don't believe, Jim. And I certainly appreciate the argument that eyewitnesses' memories fade and so forth. But in a case like this, we're talking about, there was an act of intercourse. There was no question about that. And the question before the jury was it forcible rape or was it consensual? So that was really the
You ever done this before, indicting a DNA profile? I'm embarrassed. I'd never even heard of this until this
We
case.
were the first DA's office in Massachusetts, and maybe one of the first in the nation to do it. I proposed it actually to my staff 5 or 6 years ago, and we did it, and then it was challenged, and the Supreme Judicial Court in 2010, Commonwealth versus Dixon was referred to in the piece by Adam, supported that. It's sufficiently descriptive. In fact, it's unique, one's DNA profile.
It's great to hear that woman say go from victim to survivor.
It was heartwarming, actually, really.
Can we talk about this Baby Doe? Was it 44 days, 40-some number?
It's been, yes.
Are you any closer to finding out who this kid is than you were at the beginning of this?
Candidly, I have to say no. I mean, it doesn't mean from a lack of effort or a lack of work. I mean, the investigators, prosecutors that are working the case, the state troopers assigned to my office, everybody is doing just amazing work. I'm very proud of them. And having said that, I can't say here today that we're any closer to resolving.
Can I ask you the question? I'm sure this is the one you're tiredest of. How can a kid just disappear without, even if the family is not concerned, assuming that they may be involved, someone who knows the family, knows there's a kid who belongs in this neighborhood, in this house, who's not there? How is this even possible?
It is astounding in today's day and age, I think. We've gotten hundreds and hundreds of tips. None of them have panned out, so people are alert to somebody in the neighborhood that they haven't seen for a while, things like that, and we're getting those suggestions, those tips, but it just hasn't turned out to be.
What's the working theory? They're body washed up on shore. Emily Rooney did a wonderful piece here a week or so ago where she described how complex it is to maneuver this island, which is a lifelong Bostonian. Most people don't even know how to do it, not I, but others. What's your working theory? That someone drove there, deposited the little kid's body, it washed up on shore, there was a boat, even though that's a dicey proposition. What's the theory?
Well, to your first point, I've been the district attorney for nearly 14 years, and I had never been to that island until I went out there after this happened. So, you know, one theory is that the person is familiar with the spot. It's not some place that somebody who's unfamiliar with Winthrop, for example, or that area would have.
That's what you believe.
Yes, so
and
that's a theory.
Doesn't this pollen that apparently is around the body, which allegedly is locally sourced, lend credence to that notion too?
It does.
Which makes it even more unbelievable that no one identifies the kid.
And a lack of decomposition would suggest that it was a recent, so in other words, she wasn't in the water for any long period of time. We're not even sure if she was deposited in the water, for example, and washed up on shore. She could have actually been deposited on the shore. There was water in the bag. So it, you know, the body in the bag did go out into the water. It could have been with the tide, for example, or the culprit, perpetrator, what have you, put the body in the water and it washed back up. So.
Can we get you to weigh in on a couple of big criminal justice debates that are going on? And you're part of some of these things. Body cameras. Police chief, somewhat reluctant, I think it's fair to say. He said it here. Mayor, same sort of deal. Where are you on these?
So we've had some discussions on this, and you know there are a lot of issues involved with it in terms of privacy of the officer, aggregation of the data, and so forth. But as I've said almost from the beginning, I'm open to this. I have seen the power of video evidence. When I was a young prosecutor, there was no evidence. We got maybe a grainy bank video or something. You couldn't discern who the heck the person was. Today, powerful high-definition video is making so many of our cases. It's the first really order of business today. So, you know, this.
Well, look at the Tsarnaev case, which is probably etched in the minds of everybody watching this show and beyond.
I was down there on Boylston Street. I saw the high-end cameras. I knew that was going to solve the case, and it did. So, you know, but at the same time, it's a costly proposition, and I respect some of his arguments, that is the police commissioner's arguments about how it might impact community policing and so forth, but it has to be, I think, studied.
It's happening. It's going to happen. I mean, the genie's out of the bottle. It is going to happen here at some point. It's just fine-tuning the privacy issues, the storage issues, but they're going to come, are they
Sure.
not?
I think a pilot program might be in order here, and I would encourage them to do that, but I respect, I work closely with them. I understand this aggregation of the data issue is a huge one because, and when does the camera go on, and when is it accessible to defense attorneys? For example,
But a lot of that's addressed in the bill, the measure before your former body, the city council, no?
You know, I know there's a bill there.
Okay.
I have to admit I didn't read the ordinance carefully.
One last thing before you go. You're in a war of words, which I think is being mild, with the Chief Justice of the SJC over mandatory minimums, which mandates certain specific prison terms for certain crimes. Here's what he said. Mandatory minimums punish drug couriers as if they're kingpins, place a financial burden on the state where prisons are beyond capacity. They're unfair to minority populations. Where's he wrong and you right, Dan Conley?
Well, first of all, it's not really a war of words, and you said to put it mildly.
Well, I think it is.
We have a difference of opinion, but we respect each other's opinion. I mean, we had a water summit, not a beer summit.
Okay,
I'm the DA.
fine.
He's the Chief
Where's he
Justice.
wrong,
We had
though?
some water. Well, he's wrong on a couple of points. First of all, there is no mass incarceration in Massachusetts, and there is mass incarceration in Texas and in Florida and in California and Louisiana, and those states and others like them really should take
We're
a
spending
serious.
a ton of dough on having people in prison for low-level offenses.
You know
are we
that we've
not?
had a 14% decline in our prison population in the last 5 years, and we're one of only a few states that are expected to have further decline. And we did last year, and in my office, only 4% of individuals were incarcerated by a judge after a conviction, 4%. So we're not over-incarcerating our people. So he's wrong on that point.
Is there a place to is there a middle ground on this issue?
We, meaning the district attorneys, proposed a substantial reduction in 2012 on the explicit promise by the legislature that we would invest in reentry and other probationary services. And unfortunately, you know, that didn't happen. So we have to figure out how do recidivism is the point, and the chief and I agree on this. He and I, because about a third of the population in prison today is there as a result of a probation violation. So in other words, a judge with total and unfettered discretion sent that person to jail.
Dan Conley.
Okay,
Good to
thank
see
you.
you.
Good
Be
to
well.
see you too.